What does it mean if the defense gives you the full value of what your attorney has demanded as its first settlement offer? Would you like to know what it means? Come join me for a walk through the neighborhood as I tell you exactly what it means. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. In my opinion, it means your attorney has made a strategic error. In my opinion, your attorney has made a strategic error in valuing your case as well as conveying the demand in your case. Now, let's go back for a second. Let's say this is a medical malpractice case where you sued your doctor claiming that he was careless and caused you significant harm and injury. And throughout the course of the litigation, your attorney has told you repeatedly that the defense has acknowledged that they will never, ever settle this case. They have told you that they will not accept responsibility, and now they will see you at trial. So you resign yourself to the fact that you are going to have to try this case and have to have 6 members of the community decide your fate as to whether or not the doctor was careless, whether or not the doctor's carelessness caused or contributed to your injuries, and if so, how much your injuries are actually worth. So now, as your case is on the trial calendar getting closer and closer to trial, your attorney calls you up one day and says, listen, I just want to let you know I got a call from the defense. They have reevaluated their position and they want to start negotiating. And now your attorney has a lengthy discussion with you about the risks, the benefits, and the alternatives of going through settlement discussions, as well as the risks and benefits and alternatives of going to trial and what the outcomes could be. So now you turn to your attorney and say, well, what do you think? And your attorney says, I think the value of your injuries are worth $1 million. And you say, okay, that's fine, but what are you going to ask the defense to go ahead and pay to settle this case? And your attorney responds, $1 million. And not knowing whether that's a good thing or that's the appropriate strategy, you accept what your attorney has to say because he's guided you properly the entire way through this litigation, and now you still trust him. But now your attorney says, listen, I think your case is worth $1 million. I'm going to demand $1 million. That's problem number one. So now he gets on the phone with his opponent, your adversary, and he says, listen, I want $1 million to settle my client's case. And he says, okay, let me talk to my principals and see what they have to say. A few days later, the defense attorney calls back, and now he tells your attorney, I've got great news. We've evaluated the case. We've evaluated the risks of going to trial. We've talked to our expert, and we would like to settle this case. We are willing to offer you $1 million right now. And your attorney is shocked. He's at a loss for words. He is flabbergasted. Why? Because never in his career has a defense attorney, as their very first offer, turned around and offered exactly what the demand was. And now there are red flags flashing in front of your attorney's eyes, and lots of questions begin to jump up into your attorney's mind. And the first question that he should be asking himself is, what just happened here? What just happened that I made a demand of $1 million, and a few days later the defense comes back and as their very first settlement offer, offered $1 million to settle this case? There was no discussion. There was no negotiation. He made an offer. They came back and said, yes, we will accept your settlement demand. We will pay you the $1 million. Let's mark this case settled right now. Well, now your attorney is likely going to call you to tell you the great news that they have just offered $1 million to settle your case. And you are thrilled. You are so happy. You don't have to go to trial. And now you've received a substantial settlement offer that you believe will now justify all the time and effort and energy put into going forward with this litigation. However, what you don't know is that your attorney may just have done a significant disservice to you, and you may not realize it. And I question whether or not your attorney is actually going to own up to it and tell you about what just happened from a legal standpoint. Now, what do I mean? What I mean is, if your attorney thought that your case is truly worth $1 million, after doing his legal research and identifying other cases, similar cases that have settled, and identifying other cases similar to yours that have gone to trial and gone to a verdict and gone up on appeal, and now an appellate court has made a decision about what the appropriate value for these types of injuries are. Your attorney should have a clear-cut understanding of the value of your particular case, which is probably different than some of the cases that he reviewed to evaluate the risks of going to trial or the risks of accepting a settlement offer. the question that you asked earlier, which was, well, how much will you be asking the defense to settle for? The response is, I'm not going to ask them for exactly what your case is worth. Why? Because in response to that, the defense will pretty much always make a lowball settlement offer. They will always come in with significantly less than what your attorney is demanding to settle this case. I've been in practice more than 36 years now, and I have never seen an instance where the defense comes in and offers exactly what we are demanding as its first offer. There's a bit of negotiation that goes back and forth. The defense wants a discount to try and negotiate this case as a guaranteed settlement, as a guaranteed payout, as opposed to going to trial where neither side knows what's going to happen ultimately. So the first thing that your attorney should be thinking when the defense came back and said, yes, we will pay you $1 million, and there's no negotiation, your attorney should be thinking, oh my God, I just made a huge, huge mistake. I should have demanded double that. I should have demanded $2 million or $3 or $4 million. And then they could have had more negotiation. They could have had any negotiation. Instead, there was no negotiation, which means to me that the defense attorney recognized that this was a gift, that they made a mistake, that the plaintiff's attorney, your attorney, made a mistake. And it was such a lowball number that they couldn't pass up the opportunity to go ahead and agree to this settlement offer. That offer tells me that the defense recognized that they had much more exposure and much more liability than your attorney recognized. So when the defense turns around and makes that settlement offer, and now they offer exactly what your attorney has requested, your attorney has likely shortchanged you. Why? Because he failed to recognize that the demand is not what he believes the true value of your injuries are. If your injury is $1 million, you don't make a demand of $1 million, because then the most you can ever expect to achieve is $1 million through settlement. You can never get more than that, and it is unlikely that you will get to that point, except in this hypothetical scenario. So they will come back with a lowball number, and then they will increase incrementally until finally, after full-blown negotiations, maybe they offer $500,000 or $600,000, because they are hedging their bet. They're making a substantial settlement offer in the hopes that you recognize that there are risks to going to trial. But when they go ahead and make a full offer as its very first offer, your attorney has likely done something wrong. And now, conveying that demand is likely what happened here that should not have happened. Instead, the demand should have been much more substantial, so that now the attorney should have said in the back of his mind, holy cow, I should have demanded $2 million, $3 million, $4 million, because if they were so quick to offer up $1 million, and now here I am stuck at $1 million, now I've got a problem. And the problem is that your attorney has told the defense attorney that you will accept, and now we can settle this case for $1 million. Okay, so you might be asking another question. Can you invalidate this settlement offer, even though your attorney has accepted it? And the answer is maybe. There may be an opportunity for you to go ahead and invalidate it. Your attorney will look like he has egg on his face and be entirely apologetic and be embarrassed with the defense attorney as well as their principals. There are specific instances in which you might be able to do that. However, if the settlement was done in open court, where you were now called to the witness stand and asked questions by your attorney, as well as the judge about whether you were agreeing to this settlement, and now you were doing it freely, and you were aware of all the risks of accepting the offer, that you could not come back, you could not reopen this case, you were aware of the risks of going to trial, and rather than going to trial, you accepted this offer. If this was done in open court, you may not be able to go ahead and invalidate this settlement agreement. However, there are other instances where this is simply a verbal agreement amongst the attorneys, and now nothing has been documented or finalized on paper, and now the terms of the settlement agreement have not been finalized. In that instance, there may be a possibility to invalidate this particular settlement agreement. Now, if that's true, if you are able to invalidate it, does that mean that your attorney can now go ahead and continue settlement negotiations? In all likelihood, I think your attorney is going to have a very difficult time continuing settlement negotiations, because that level of trust will likely be gone now. and the defense attorney will likely no longer trust your attorney and what he has to say about whether or not he would agree or not agree to any particular settlement offer. So I think at that point, your attorney and you will have a very difficult time trying to negotiate your case further. So why do I share this quick information with you? I share it with you to open your eyes and to help you understand how these types of cases work in New York. You know, I recognize you're likely watching this because you have questions or concerns about your own matter. Well, if you are considering bringing a lawsuit but have not done so because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.